friends. This is Casey Ashmore. I'm coming to you from the studio today, and I'm going to talk a little bit about one of the things that I warn clients all the time about when they're entering into contracts, and that's binding arbitration agreements. I'm not a big fan of them. Doesn't have anything to do with the AAA. I think they do a great job. Doesn't have anything to do with professional arbitrators. I think they do a great job. There's no way in heck it's cheaper, faster, and quicker than the relief you get at the courthouse. Just not true. It's 10 times as expensive in my experience. Everybody's got to pay the AAA about, depending on what the amount in controversy is, somewhere between $5,000 and $25,000 to try. That's the administrative fee to pay the case, to try the case. Big dollars. Filing fee at the Rockwall County Courthouse, $340. Filing fee at the Dallas County Courthouse, $340. Filing fee in the Cameron County Courthouse, $340. That's cheap, right? You're paying taxes, right? Your business is paying taxes. Those taxes go to fund the courthouse, the judges, and the judicial staff, and to send out the jury summons if you have a jury trial. So why are you going to pay all those taxes, not use that service because you want something cheaper and faster? No. That's not how it works, okay? It's not cheaper, it's not faster, it's longer and more expensive generally. Because guess what the AAA has no authority to do? Issue service of process in compliance with our due process laws in the United States of America so that you can put a defendant on notice that they did something wrong in a civil claim. So let's say you've got a commercial property that you're building out. Something goes wrong, there's a dispute. The dispute has a binding arbitration agreement. You still have to file a lawsuit to put them all on notice so that way they're all sued, and then the case gets referred to arbitration. Because guess what? If it goes to arbitration and you don't have a lawsuit pending, you get an arbitration, then you have to file a lawsuit to have that arbitration judgment enforced. So no matter what, you're still filing $330 worth of lawsuit some point in an arbitration, right? There's nothing cheaper, faster, smarter about this. Now, I will tell you there are alternatives, and I'm not saying, look, I'm not beating up on the AAA, I'm not beating up on professional arbitrators. They do a great job. They really do, and I can see in theory how the idea of arbitration was, helpful, beneficial, streamlining, right? I can see that in theory, but I would say in practice, in my experience, it's anything but. Because you don't have the right to a jury, at least that part's faster. Like right now, there's no juries going on because of coronavirus, but that's really the only thing it has beating the regular court system on expediency. And a jury trial can slow things down because those are different settings and there can be other problems. The nice thing about a non-jury case is that the judge can try it anytime. The judge has some free time, 2, 3, 4 days. If it's a complicated matter, 5, 1, 2, 3, 4. Judge is going to go through those witnesses, hear all that testimony, excuse all the parties. You'll have a ruling within 10 days. Sometimes, maybe a little longer, but only if other things are going to happen. Like the judge might hear all the evidence, refer the parties back to mediation, and then come back, after the mediation is successful or not with a ruling so many days after a second referral to mediation. These are just the things that can occur in a bench trial setting. But I would say there's another alternative, and that's the whole point of this video series, is not to talk about what I don't or in my experience, my clients have not liked about arbitration, but it's to talk about there's another alternative. So if you're out there and you're looking at commercial properties and you're looking at commercial building contracts and you're looking at this and you're looking at that and there's arbitration clauses in there, be advised that Texas has its own alternative to that, right? It's got its own alternative to that, and you can agree to that in part of your business contract instead of an arbitration clause that must be administered through the AAA. And let's just face it, folks, those fees are high. They can be 10 times higher than litigating down at the courthouse because you're paying all the professional time of the arbitrator and all of your attorney's fees, right? And the AAA's fees are significant because they're going to put either a panel of judges together or a single judge together. Those are significant fees. Anyway, more on this video series next. Thanks for watching. If you have additional questions, chat at ashmorelawfirm.com, chat at ashmorelawfirm.com, or text Ashmore X2 to 47177. Text Ashmore X2 to 47177. Thank you.